Durham Superior Court Judge Carolyn J. Thompson's August 15, 2018 unfavorable ruling in Crystal Mangum's malicious prosecution civil lawsuit set the appellate process in motion, the judge's order being filed 5 days later on August 20th. With assistance from Dr. Haar, a friend and advocate of Mangum, her appeal was manually filed with the North Carolina Court of Appeals in Raleigh on February 1, 2019. A three-judge panel consisting of appellate judges Berger, Dillon, and Zachary heard the case in conference on May 8, 2019. Three months later, on August 6, 2019, its six-page opinion was filed, being drafted by Berger with Dillon and Zachary concurring. Inaccuracy in the opinion is apparent in the opening paragraph with a statement that the appeal contained 13 issues when in fact it contained 10. This is not a materially important discrepancy, but lends weight that this appellate panel did not consider this case with the seriousness it deserved. The last sentence of the first paragraph reads, quote, "However, because the trial court did not err, we need not address each of her arguments," unquote. Right up front, the panel provides an excuse for not answering the tough issues, to justify cherry-picking the issue most favorable to defendants Durham Officer Marianne Bond and Durham District Attorney's Office. The vagueness of the sentence makes it unclear as to whether or not such an appellate judge rule exists with regards to appellate issues to be addressed. Its implication is that such a ruling is on the books, but since there is no citation given, it is very likely that none does. For example, in judicial conduct rules, are there conditions under which the appellate panel is not required to address any of the issues on appeal? Does a panel finding error in the lower court ruling require a response to all issues on appeal? Clearly, the reason that the appellate panel doesn't want to address all of the issues on appeal is because there are several issues wherein reasonable arguments cannot be made in support of the lower court ruling, in particular issues 1 and 4. The three-judge panel steered well clear of issue 1, which deals with a procedural error which denied plaintiff pro se Mangum of due process, namely deprivation of her work product prior to her court appearance, and forcing her to proceed in court from memory alone. This is unheard of. That unfair occurrence makes this case not only one of first impression, but also worthy of publication. Because the three-judge panel could not produce a logical argument or case law to counter this first and most important issue on appeal, it took the only path available. It ignored the issue. The same for issue 4, which dealt with the pre-filing injunction. The lower court gatekeeper ruling on Mangum's complaint by Judge Thompson was baseless in that the case lacked any connection to Haar's lawsuits against Duke University and WRAL-5 News. Additionally, in an effort to clarify his lawsuits and their relationship or lack thereof to Mangum's, Dr. Haar was prevented from addressing the court from the gallery or witness stand by Thompson. Additionally, Haar could have guided the court through his exhibits manual that Mangum presented early in the session. The remaining 8 issues on appeal were deserving of good faith consideration by the three-judge panel, which had no appetite for their legal analysis and discussion. Instead, the panel restricted its efforts to issue 2, the defendant's statute of limitations argument, and its interconnected Issue 6 dealing with the tolling of the statute. The statute of limitations in the malicious prosecution complaint has to do with a charge of larceny of chosen action related to the 2 cashier's checks. The panel, in its section on factual and procedural background, disingenuously misleads with its statement, quote, that he, Reginald Day, wanted 2 money orders plaintiff had taken returned to him so that he could pay his rent, unquote. In rephrasing Officer Bond's April 4, 2011 police report, Day actually stated that he gave the cashier's checks to Mangum, not that she had taken them. This difference is at the crux of the larceny charge. The panel presented a biased and inaccurate account. Then, in summarizing Mangum's complaint, the 3-judge panel acknowledged 3 issues, but made no mention of the most important issue in the complaint, the lack of probable cause. The panel follows up in restating Mangum's elements of her complaint with the following, quote, the state's prosecution evidenced malice because of plaintiff's role in the Duke Lacrosse case, unquote. This is false and misleading. Mangum's position was that malice was evidenced by 1. Collateral purpose of utilizing the felony charge to justify elevating the murder charge to first degree through the felony murder rule, and 2. Defendants knew at the time of presentation of their case before the grand jury that the larceny charge was baseless, that is, without probable cause. Panel then cherry-picked the Bond defendant's May 22, 2018 responsive brief as representative of both defendants because it utilized the Rule 12b-6 failure to state a claim defense. The issue it raised had to do with the 4th element regarding a favorable outcome in the original case. This defense, argued by Attorney Rayberg, stated the following in paragraph 6, quote, defendant Bond contends that the not guilty verdict 2 of the 3 charges at the November 2013 trial does not qualify to meet the 4th element of a malicious prosecution claim against Bond under North Carolina common law, since plaintiff was in fact convicted of the murder charge, unquote. Clearly, Mangum's malicious prosecution complaint has nothing to do with the murder charge, making this argument so weak and indefensible that Rayberg did not use it at the August 15, 2018 hearing. Defendant Durham District Attorney's Office never used the Rule 12b-6 defense in any of its briefs or at trial. As recited by Attorney Shields, the defenses of the Durham DA's office were limited to improper service, lack of personal jurisdiction, untimely filing, and qualified immunity. The only reason the May 22, 2018 brief by Defendant Bond was mentioned by the 3-judge panel is because it listed the Rule 12b-6 defense, which suggested that the merits of the case were being challenged. Again, by the time of the August 15, 2018 hearing, that defense had been jettisoned and not even entertained at the hearing. Finally, in its background, panel misrepresented Mangum's arguments by stating that she insisted that the statute of limitations had not expired by her January 2018 filing. This is incorrect, as Mangum was well aware and conceded that the 3-year statute had expired on November 22, 2016. This is reflected in her briefs and statements. Her defense had been that during the 3-year period, she had been represented by attorneys who failed to file the complaint or inform her that she had grounds for such a lawsuit, thereby committing either fraud and/or mistake. Simply stated, they were not representing her with her best interest as a priority. Mangum did suggest that January 17, 2017, the date of the North Carolina Prisoner Legal Services letter, which abandoned her as a client, should be used as a date for the statute of limitations to accrue. Regarding the North Carolina General Statute 1-529 exemption, Mangum argued that the issue of fraud and mistake had to do with her legal representation during the 3-year period of timeliness. Mangum relied upon her legal counsel to represent her best interests, and during that period, Dr. Haar did not involve himself in her case. If not fraud, then Mangum's attorney's failure to act on the malicious prosecution issue was definitely a mistake. Though Mangum's case was primarily one of malicious prosecution, it also included ineffective counsel and the commission of fraud by her attorneys. Special consideration of culpability by her attorneys is that Mangum discharged her first appellate attorney, Peterson, and filed a grievance with the state bar against her. The North Carolina Prisoner Legal Services, as the name implies, is a state agency which did nothing for her during its representation, which was terminated when it abandoned her months after the statute of limitations expired. In its analysis, the panel cited Congleton v. City of Asheboro with the following excerpt, quote, "Statutes of limitations are inflexible and unyielding. They operate inexorably without reference to merits of plaintiff's cause of action," unquote. Even the North Carolina Court of Appeals does not strictly adhere to its own statutes of limitations. An example in Haar v. WRAL 5 News has to do with Haar's motion for publication of an unpublished opinion. North Carolina Rules of Appellate Procedure permit only 10 days from issuance of an opinion for such a motion to be filed. Rule 30E4 reading, quote, "The motion shall be filed and served within 10 days of the filing of the opinion," unquote. On June 4, 2019, the North Carolina Court of Appeals filed its unpublished opinion in Haar v. WRAL 5 News, and 20 days later, on June 24, 2019, Plaintiff Pro Se Haar filed his motion for publication, its filing being twice the 10-day filing period allotted. The Court of Appeals did not disqualify the motion due to the timeliness issue, but instead dismissed it based on what it construed to be the merits of the case. In Haar v. WRAL 5 News, the North Carolina Court of Appeals was flexible and yielding when it came to its own statute of limitations for filing. Congleton v. Asheboro goes on to state, quote, "The purpose of a statute of limitations is to afford security against stale demands, not to deprive anyone of his just rights by lapse of time," unquote. Clearly, Mangum's murder case is not stale. Certainly, there is nothing magical about 3 years pertaining to staleness of a case. The 3-year statute of limitations is purely arbitrary. It could easily have been 2 or 5 years. The Congleton excerpt concludes, quote, "In some instances it may operate to bar the maintenance of meritorious causes of action. When confronted with such a cause, the urge is to write into the statute exceptions that do not appear therein. In such case, we must bear in mind Lord Campbell's caution, quote, 'Hard cases must not make bad law,' unquote." In other words, the North Carolina Court of Appeals agrees with Congleton and Lord Campbell that meritorious causes of action, such as Mangum's, must be sacrificed to be in strict adherence to man-made law. The Florida Supreme Court takes a different view when the issues of law and justice are in conflict. This is expressed in its opinion in Strazula v. Hendrick, which states, quote, "An exception to the general rule binding the parties to the law of the case at the retrial and at all subsequent proceedings should not be made except in unusual circumstances and for the most cogent reasons, and always, of course, only where manifest injustice will result from a strict and rigid adherence to the rule," unquote. Pertinence with regards to the statute of limitations presents itself in the St. Louis, Missouri case of Lamar Allen Johnson, a 45-year-old African-American who has served nearly 25 years of a life sentence without the possibility of parole on a murder conviction. CNN, in an August 29, 2019 article, gave the following account, quote, "Lamar Johnson was convicted in 1995 of the murder of Marcus Boyd, who was shot to death a year earlier on the front porch of his apartment by two masked men. Police said at the time that Johnson and another man, Philip Campbell, fatally shot Boyd following what witnesses suggested was a drug dispute. But Campbell and a man named James Howard later signed sworn affidavits admitting they killed Boyd and that Johnson was not involved, according to court documents." A report from St. Louis Circuit Attorney Kimberly Gardner and the Conviction Integrity Unit outlined what her office called misconduct by police and prosecutors in the case, including perjury, false testimony, and the payment of more than $4,000 to the sole eyewitness. The witness later recanted.
A Missouri judge cited filing deadlines when she said it will not allow a new trial for a man prosecutors say has wrongfully been imprisoned for nearly a quarter century, according to the Washington Post. St. Louis Circuit Attorney Kim Gardner moved for a new trial for Lamar Johnson, who was sentenced to life without possibility of parole on murder charges in 1995. The conviction Gardner's office said was secured through fabricated evidence and bribing an eyewitness who recanted his testimony, according to the Post.
A July report by the Conviction Integrity Unit in Gardner's office cited numerous errors and examples of misconduct by police and prosecutors that deprived Johnson of a fair trial. Conviction Integrity Units have been created in various United States cities to review post-conviction claims of innocence and exonerate wrongfully convicted defendants. Johnson's case is ultimately about innocence, the report said. Johnson did not shoot Boyd and had nothing to do with Boyd's murder, and he should not be in prison for the crime. Imprisonment of an innocent person constitutes a manifest injustice, unquote. The CNN article continued, quote, "Circuit Judge Elizabeth Hogan ruled last week that the court had no authority to grant a new trial because the motion was, quote, filed approximately 24 years, unquote, after the mandated date of 15 days after the verdict." In late August 2019, the prosecutor in Johnson's case and its Conviction Integrity Unit asked the court for Johnson to receive a new trial. An article from The Hill dated August 27, 2019 reads as follows. Hogan said she consulted with the State Attorney General's office, which told her Gardner's office does not have the authority to ask for a new trial. She also consulted as to whether Gardner accusing her own office's prosecutors of misconduct constitutes a conflict of interest, which, in an amicus brief, more than 40 prosecutors argued, contradicted a prosecutor's ethical duty to remedy wrongful convictions. quote, as a duly elected minister of justice, a prosecutor's obligation to correct a known injustice never terminates, unquote. They wrote, quote, and because that obligation never terminates, neither does the prosecutor's right to pursue an appropriate remedy in court, as the circuit attorney has done here, unquote. The evidence is overwhelming, Johnson's attorney, Lindsey Runnels, who, along with the Midwest Innocence Project, also plans to appeal the ruling, said via email, quote, the state agrees, and in the interest of justice and fairness, that should be enough to overcome a missed deadline, unquote. The North Carolina Court of Appeals would applaud Circuit Judge Hogan's ruling to have Lamar Johnson serve out his life sentence despite objections by the prosecutor, Conviction Integrity Unit, and Innocent Project, because doing so would be in accordance with strict adherence to the law. The Supreme Court of Florida would rule alternatively by granting Lamar Johnson a new trial, because failure to do so would represent manifest injustice. Returning to Mangum's malicious prosecution case, Judge Thompson and the appellate panel tried to subtly insert merit as being a driving force in their decisions, when it undoubtedly was not. Mangum more than met the bar for proving malicious prosecution, and the defendant's arguments were solely based on trivial and contested legal technicalities. Decisions in Mangum's case in both the lower and three-judge appellate panel were motivated by a desired outcome rather than being based on facts, fairness, and merits.